Hello, everyone. Mark Isaacs and I decided that in preparation for our weekly discussion in this course around segregation and the integration of schools, that we would provide just a brief historical overview of some of the key Supreme Court cases that have dealt with this topic. So to begin, the first segregation laws, known as Jim Crow laws, were passed in Tennessee in 1881. This was following the Reconstruction period. And the first major challenge to these laws reached the Supreme Court in 1896 in the case of Plessy versus Ferguson. But in this decision, the Supreme Court ruled against the plaintiff, Homer Plessy, denying him access to a whites-only section of a train in Louisiana. So from that point forward, segregation was declared legal. They used the phrase separate but equal to justify segregation in all public facilities. So for the next, 30, 40, even 50 years, segregation was the law of the land in the South legally. And this man, Charles Hamilton Houston, is referred to as the man who killed Jim Crow, because what he did as a Harvard-educated lawyer is he exposed the hypocrisy of separate but equal. He used, cameras to basically prove that the facilities were not equal. Now, sadly, he did not live to see the historic decision in the 1954 Brown versus Board of Education in Topeka, Kansas case, but he was largely responsible for the work behind the scenes. So this case involves Linda Brown, whose father, Oliver Brown, and along with 12 other families, filed a class action lawsuit against the Board of Ed in Topeka, Kansas. The lawyer from the NAACP was Thurgood Marshall. He will later become the first African American on the Supreme Court. And in this decision, the court ruled 9-0 that segregation in schools was unconstitutional. Now, there was no determining factor on when this should be implemented. So 1 year later, in a decision that's known as Brown 2, the court ruled that states had to comply with all deliberate speed. Slightly more specific, but still providing too much leeway for states to try to circumvent the law. One of the most well-known incidents during the Civil Rights Movement took place in 1957. This was in Little Rock, Arkansas, in which 9 black students were selected to be the first ones to enter and enroll in Central High School. But the governor, Orville Faubus, refused to allow this to happen. So he called in the National Guard, took them under his control, and denied entry for these 9 black students. Fortunately, the president, Dwight D. Eisenhower, sent in troops under his command, took charge of the National Guard, and these 9 black students were escorted into school. It was a very tumultuous, chaotic, very difficult, challenging time. There's an awful lot that's been written about this time period. And just to show you how strongly opposed the governor was, in the following year, he simply closed down the school for all residents. Nobody could go to Central High School for 1958 and 59, I believe. So now we fast forward to 1968, and this case out of Virginia, Green versus the County School Board of New Kent County. What the states had decided to do in the South is they passed these freedom of choice laws. So they were supposed to allow each student to decide which school he or she wanted to go to. But in reality, segregation just continued all across the South. So even though they were on the surface supposed to promote integration, the challenge that reached the Supreme Court in a 9-0 decision, the court said these are just not adequate. These laws are not promoting racial integration. So this is another victory for the cause to promote integration, but again, the pace is just far, far too slow. So then we go to 1971, and now this case, Swann versus Charlotte-Mecklenburg Board of Education, this deals with the issue of busing. So the petitioners in this case said, yet again, that integration is not happening fast enough. So what the court ruled here is that in order to implement this, since most people now go to school where they live, and since our living communities were also largely segregated, school districts can implement what is known as busing. So in order to promote integration, we can send students further away from their homes to provide for more racial equality in the makeup of the schools. And busing is still continued throughout the country. For those of you that were paying attention to the presidential debates early on, this was a debate between Joe Biden and Kamala Harris in terms of his lack of support for busing, and Kamala Harris arguing she was one of those students who was bused to promote integration. Now, this case is not as well known, but it has tremendous significance to our discussion, I think, for this week. Milliken versus Bradley dealt with Detroit. Now, I think one of the things we will focus on is our school districts are, largely drawn around where you live. And if you live within the city limits, you're required to go to school in the city. And if you live in the suburbs, many of our suburban districts are much narrower in how they are drawn. And that's how we basically have segregation. It's like de facto segregation. It's not by law, but it's simply by the common place of where you live. So this case originated in Michigan. And what the NAACP said is that Michigan is responsible for the segregated living conditions that existed in the state, that they blamed a practice known as redlining, where mortgage rates and where people could get a mortgage was largely determined by your race. I won't digress too much about that, but we can talk about it in the discussion if you'd like to. So they blame Michigan for having a city system that was largely African American and a suburban district that was largely white. So they felt as if to make this situation better, the district had an obligation to combine both districts. And a federal judge agreed with that ruling. But then it was challenged to the Supreme Court. And as you can see, in a very narrow decision, 5-4, Supreme Court overturned that lower court's ruling. So the court said it's not the state's responsibility for the fact that people are living in segregated communities. And again, I think that's going to have a lot of relevance to our discussion for how we can solve and implement policies that improve this situation. And then the last case we focused on is a more recent one in Seattle and in Louisville. And these two cases were combined together. These are two school districts that try to, again, promote racial integration. So in Seattle, they allowed students to select the high school of their choice and they ranked them. But if there was a tiebreaker needed, they used race to determine which student would go to which school. Then in Louisville, their policy was none of the high schools could have fewer than 15% African American populations or more than 50% African American populations. And parents in each of these districts filed lawsuits. And the Supreme Court ruled that both of those practices were unconstitutional. And I put a quote there from one of the justices, Clarence Thomas, who believes that racial imbalance in schools can be dealt with with more private decisions, and it shouldn't be the responsibility of the local or state government. So I hope this helps people. We hope this helps people to have a good snapshot of how the issue of segregation in schools has been dealt with in the courts, and it'll be nice for us to then be able to connect this to some of the theories we've already learned from Vygotsky and just the whole concept of social-cultural learning environments as well. So thank you very much, and we will see you on the UB Learns website.